Welcome to the Simply Be Found Huddle, where we talk about business and being able to grow your business in multiple different spots and ways. And today we have our guest, Austin, on. Austin, thank you for joining us. It's great to have you. Can you tell everybody a little bit about yourself and what it is you do?
Well, thanks for having me. About myself, basically, I tell people I'm an engineer with a law degree. I'm not a lawyer, actually, I am, but you know what I mean. I help people get patents, trying to also guide them through the process of that and kind of their startup business and the things that they need to do. Because, when you've done patents long enough, you've seen a lot of the mistakes that small businesses make trying to build something off of a new idea.
Patents are one of those kind of odd areas. I've never really done much in that area with being in the venture capital group and doing all the stuff. I've seen some of that stuff come across, but it's not something I've ever really touched. So when you're doing patents, do you do it on products? Do you do it on processes? Do you do it on technology, or do you cover everything?
My personal practice, I basically do everything except like heavy duty chemistry or heavy duty biology.
Yeah.
I'll be the first one to pass it off. Yeah, but I've done, when we were able to patent software, I did software. I used to work for a company called Foxconn, so I did a lot of, and I was, working in their carbon nanotube technology area, and that was cutting edge and crazy stuff going on there. And then, of course, I've done things as simple as a sushi roll maker. It's all over the place.
So
Yeah.
tell me a little bit about the people that are inventors. We've had some people that have been that we've coached on some things, and everybody has a little bit of different approach. But I think sometimes they get a little bit possessive about what they're doing, and they make some mistakes. Can you tell us some of the mistakes and pitfalls that happen in that process?
Well, it goes one of either way. They're so protective. It's like their children. I mean, they treat it like their baby, and they're like, no one can touch my baby. And therefore, it never gets exposed. It never grows into anything, and it just kind of dies on the vine. I guess that's a horrible way to put it. We're talking about babies.
It's accurate. That's accurate, though.
I was going to say it's pretty damn accurate.
Yeah, exactly. But the other one is, the ones who, oh, it's my baby and I want to put it on Facebook right away. And that just disclosure kills your patents. And so, you got to keep it secret. I say even after you file the patent application, you keep it as secret as long as you can. You have everybody you're dealing with under non-disclosure agreements, because there's not just a patentable reason to keep your idea private. There's a commercial reason too. You want to be the first one to hit the market. When you hit it, you want to steamroll it. And then it takes a while for your competitors to come and get you. I mean, there's this one, these stories of like Kickstarter, people going out there, hey, I have this idea. I want to build this product, send the money to me. And they have companies overseas that are just waiting for a new idea on Kickstarter. Looks like it shows some promise, and they will hit the market before you do. And you end up looking like the knockoff.
Well, it's one of those things to where, you have that problem as well when you send your products over to China to get built. They'll knock your product off every time. I mean, any investor I've ever talked to or anybody that's had a product that went to China, it's had a knockoff that's came out of it, or some country like China, not just China. But it's one of those things to where you have to be really careful about that. And there's a cost to outsourcing and taking your products overseas for that reason, because you will have competition and they will break your patent, and it might be where it's really hard to disprove because they're over in another country and a different set of laws. Is that true still?
Oh, it's totally true. All patents are local. And, I do suggest if you know that you're going to manufacture overseas and you know which countries you're going to do it, at least apply for a patent there. I mean, the manufacturing is cheap over there. Getting a patent over there is generally cheaper as well. So my suggestion is go ahead and get it. It's not as strong as it adheres in the U.S., but you might be able to stop some of the knockoffs. But, the old adage is the factory works for you for 8 hours and your competitors for 16, right? And so one of the things that I highly stress, right? So one of the things I highly stress is that people don't use design patents enough. Even if you can't get a utility patent, which is what people generally think of as a patent, get a design patent on the exact design of your product, and you spent all this money on these molds that are overseas, and at least you can protect the design of what comes out of that mold and prevent it from coming into the US as best as possible. So it's another way to protect a product, even if it's not eligible for a utility patent. But even if you do get a utility patent, you should still cover the actual product you produce with a design patent.
So since I'm not real familiar with it, can you give me a user design and utility? Can you define those a little bit better? Because that's kind of that's new terminology for me, if you will. So,
okay, so utility patent. Yeah, the utility patent is what you believe a patent to be generally. It's you have the idea, you go out there and you protect the idea. Design patent only covers the way something looks. A good example would be in your studio right now, we were talking your microphone. You can't get a patent on the basic microphone right now, right? But you could get a design patent on the exact way your microphone product looks, and it prevents other people from making a microphone that looks just like that.
So a design patent would be like getting a patent on a piece of pizza that is designed out. I was watching your shorts this morning and I saw that one. I mean, it'd be like getting on a certain design of a pizza. You could patent that for a design patent.
Yeah, if you came up with some novel design shape for a pizza and you're like, this is my novel design for a pizza, you could do that. I mean, the question is, you might have a hard time proving that it's never been done before, but I wonder if those octagon pizzas in elementary school were, designed because they sure weren't. They weren't sold on their taste. I can tell you that.
Well, so you say that, and I laugh because remember, I don't know if you remember Rob or Austin, they came out with the octagon washer because it didn't have lost material, but it never caught on because it wasn't round. But when they stamped them out, it was an octagon shape, and it was a great idea, but people just didn't want to buy into that. So so when you said the octagon pizza, that's where my head just went just now. So
I had no idea, Dean.
I've never seen it. Yeah.
I just remember because I was I worked when I was in the corporate world. I remember seeing that come through. I thought, man, this is a great idea, but it just did not catch on.
So I mean, I've dealt with software. Look, to get software patented, it's a pain in the butt. It's almost damn near impossible. I've been in the process of breaking patents for that, for different pieces and different copyrights and all that. In my world of doing everything, I've sat in those rooms with all that happening. But so my big question is, how has AI changed patents, and what should people be aware of with all this new AI stuff coming out?
Oh, that one's a tough one. I mean, it's the, right. We don't know until the Supreme Court tells us, or until Congress passes something, because right now, technically,
they haven't done anything yet, have they?
No. I mean, it's an act of and they hate it. I mean, they hate the Supreme Court hates dealing with patents, as most courts do, because most judges did not go to engineering school. And it's just, especially when you start getting a software, and the issue with software is the fact that it's generally an abstract idea. The idea being, if some super smart person could do all the steps in their head, could they possibly violate a patent by just thinking it? And that's the issue, or one of the issues. With AI, they came out and they said that AI can assist you in inventing your invention, but a person has to be the main driver of the invention. I don't know how they're going to, do that. To me, it just seems like it's fraught with issues at this point. So I suggest to my clients, don't use it. Another thing that people want to do, they want to search their idea before they contact a patent attorney. And I think that's a great idea, but I warn against using AI because, like we said, disclosure is the killer of patents. And what are you doing when you put into AI? You literally just gave it your whole idea to the largest public database or, knowledge entity, and you've just given it to it. So my question is whether or not that's considered disclosure or not. I know that some companies can basically, form a firewall where they're allowed to pull information in and it doesn't take information out. Until someone tells us exactly those rules, I try to stay away from it.
That's good. That's a good suggestion. So intellectual patent. So we were talking about, physical patents, but like Rob's talking software. So you can patent intellectual ideas, like if somebody comes up with something like that, or is that more of a trademark or copyright kind of situation?
No, you can patent a method. So if you have a method of doing something, a process, but when it comes to software, and I get calls all the time. Hey, I have a new idea for an app, and I'm like, at the end of the day, are you basically taking information in, comparing it to a database, and then spitting out an output? That's never going to be patented anymore, generally.
Okay.
Yeah, and it's like you said, Rob. It is tough to get a software patent. I think there are like a couple exemptions. It's like, can you make the internet work better, computers work better, financial transactions more secure, or communications more secure? And those are kind of the really, but most software patents never fell into that.
Most software patents. So the problem with that for software that I've ever seen is whenever it goes in front of a judge, the judge knows nothing about it. You can spend an absolute fortune bringing in a witness, and then you got to worry about witness tampering and them getting in there, because now you're talking about millions of dollars and making sure that they're truly going to be a good witness inside of that area. And I've never seen a case go well from the ones I've been a little bit a part of. It's one of those things to where it's not worth the time and it's not worth the money spent on it, because it's going to get broke or it's going to be outdated by the time you get approved, and you would never have the market share.
Exactly.
The only thing that really I've ever seen inside of software is if it had some kind of connection to the hardware. So if you have a hardware software relationship where they rely on one another, that is a whole different game than it being just software. I mean, once it goes on the internet, I mean, there's not much that hasn't been done. We just relabel shit all the time and put new names on it. It makes it really super hard. Now, I mean, when it comes to physical, items and all of that, I've seen more people screw the goose, just like you were talking about, for sharing information. I've seen people want to get I haven't gotten my patent yet because I couldn't afford it, and I have this idea. I'm looking for you guys to invest. And then we had a fishing piece when I was doing venture capital stuff. He made a lure that could be you could attach and take your lure off real super simple. Ended up being a knockoff of somebody else, I think. But the whole thing, he ended up going to Eagle Claw and presenting the idea. Well, Eagle Claw they had their engineers inside the room, and their whole thing was, let's get this done before patent even gets put in place. I mean, you have to be really careful on it, and you might think you're going down a good way, but you have to be able to trust that person that you're getting ready to go and do business with, and you have to have those things in place. I've seen more people get screwed on that side.
Exactly. I tell people, sign the papers. You have to do the important stuff, which is, get your contract signed, your non-disclosure signed, all that stuff taken care of. And like you said, a lot of people come up to me and say, hey, well, I'll just go to these VCs. And I'm like, most VCs I know will not sign an NDA at all. They're like, no, we don't want someone coming back to us later in the future saying this product's too close to something I showed you 5 years ago.
I've seen that. I've also seen where they have you sign an NDA, and inside of their NDA, it says that if we agreed to an NDA, it's non and void.
Okay. If we happen to tell you, yes, we did this. Yes.
Exactly. Yeah. You know how many people don't read that?
That's one of the biggest things I say is read your NDA. Like, you're the one making someone sign it, at least read it. And, a lot of people think, well, they signed the NDA, that's it. And I'm like, well, did you put confidential on everything that you sent to them that was confidential? Because if you read your NDA, it tells you got to put that on there. And they're like, no, I didn't do that. They knew it was a secret. I'm like, well, it's, if they choose not to keep it secret, then but I will tell you, I did have a client one time, and she ended up having a big case against a big company, and she had an NDA that was a pretty ironclad NDA when they came in to look at her product. And the NDA said basically it covers you, your wholly, your owners, your subsidiaries, basically everyone up and down. She was about to, they said they were in a partnership together. She was about to release her product 2 weeks before she did. They released their version of it.
Oh,
And
wow.
right, even though she had the patent, she was going after them under the NDA because the NDA is much easier to enforce if you have a good binding NDA. Patent lawsuits just, can be a little difficult. I'm sure, as you know, Rob, there's actually 2 trials. The first trial is you got to make a argument and have a whole trial about what do the claim terms mean. And then you have a trial based upon that finding. So it's just a long, expensive process.
And from what I understand, that first trial is basically you prove that you even have a case. And prove that you have any right to be there. And it's almost an education piece for the judge and everybody to learn what the hell they're getting ready to see.
Oh, yeah. I mean, I've worked on some things before, and you become an expert in things that you never thought you would ever think of ever hearing before. I was helping one with one, and, it was like some kind of, I don't want to get too far into it, but it was like a function of an animal that causes them to scoot over across your carpet. And I'm like, man, come on. We had to talk about that for months, and you become an expert in it. And that was before you even got to the claim construction.
I mean, so when I sold one of my companies, I did the venture capital stuff for a while, and I was inside of that world. It was one of those things to where it was funny. I was the only person without a degree, without ever going to the bar, without doing any of those things. I didn't have my MBA, didn't have any of that stuff in there. And I'd bring up ideas inside of there that no one else was ever thinking about inside of those rooms. It was a very fun process, and it was one of those things to where I got to learn all kinds of stuff. I don't think I could have ever learned that in the 4-year college.
Well,
yeah. What are they teaching in 4-year schools anyway right now? I mean, come on, let's be honest. Yeah.
So Austin, it sounds like you spend more time on the legal side of it than you actually do the patent sometimes. Is that kind of a,
No.
Okay.
The majority of my work, I always said, like, if you find me in a courtroom, bring bail money because I'm scared.
So how long does it usually take to get a patent? And what's that process look like?
Oh, it's okay. So, to write and file, prepare, all that stuff can take a couple months, if that long, just depending on the back and forth. The searchers, are they busy? The draftsmen, are they busy? Those kind of things. But once you file it, you're generally looking at 2 to 3 years before anyone even looks at it at the patent office. And then you're generally looking at a year after that of arguing back and forth with the patent office if it's going to get through. But I've had some that's taken 5 years, 6 years.
Now you may not want to answer this question. You can, and it's fine if you don't. What does it usually cost to get a patent?
Oh, no, I don't mind that at all. I mean,
okay. Some people would be like, I usually don't like to bring up cost, but I think that's something that a lot of people don't realize how much it actually costs to get through the whole process.
Right. And the thing is, you're going to get your typical lawyer answer. It depends, right?
Yeah.
The beginning stages, I have pretty good estimates. Like the prior art search phase generally costs a client between $1,000 to $1,500. Okay. Then the writing phase, which includes the writing the application, the draftsman's fees, and the USPTO fees, basically getting something on file at the patent office, you're generally looking at something between $5,500 and $8,500 for that. And so I know it's a big scale, but I've also had some that cost less. I've also had some that cost more. It just depends upon the complexity and the amount of time that it takes. After that, we sit, we wait, and now you're dealing with the patent examiner. And while there's only one patent office, there's 9,000 of them. So there'll be times that you're preparing an application and you think you might have a weak spot over here. And then out of nowhere, the examiner's worried about something over here. And you're like, wow, okay, I guess that's where we're going with it. So, sometimes you deal with that. You're dealing with personalities, you're dealing with people. So it can go back and forth. It also depends on what the client wants to do. Sometimes the examiner gives us, an easy way out, but we have to give up a lot to get there. And sometimes, the client's like, I don't want to do that. I want to fight for the broadest patent possible, and that will bring you down the line. And at that point, you're kind of dealing in I don't want to say litigation. You're in a negotiation, and it depends on how hard the sides want to be.
Gotcha. So I'm going to ask a question. It's a little bit different than just filing a patent. I had a friend of mine who is a chemist, and he came up with a better way to make batteries more efficient. This was 30 years ago or so. And he said that he did a patent pending kind of thing on something that he had started with that. Is that a good approach to things, or is that not the same? I mean, this was a few years ago. It may not be the same based on the laws today, but
Right.
is there protections on patent pending kind of things?
Well, there's never been protection on patent pending. Patent pending just means you have something on file at the patent office.
Gotcha. Okay.
It puts people on notice that, hey, I might get a patent on this, and if you choose to go down this route, you may get a cease and desist letter at some point. So, buyer, beware moving forward. Obviously, it can get overused. I wonder if what your friend was talking about, they did the whole thing where they used to mail it to themselves. And, this was considered the cheap patent. That is dead and gone.
Okay.
So
that sending a certified letter to yourself as history is not a viable process, because I've heard that people doing that for other things like trademarks and registration marks too. That's a way of doing that. It sounds to me like that's no longer viable. Is that what you're saying? For the most part?
When it comes to patents, with the U.S., we used to have a first to invent system, and then when you had people caused too much litigation, and finally the U.S. said, "Forget it, we're done. First one in the patent office wins. End of story. That's it. Unless you can prove, that you derived it from the original inventor. That's the only argument that can be had now. But that's why you got to get to the office as fast as you can and get that patent pending status first.
So at what point, how long does it usually take to get to a patent pending to where you can go to market and know that you're already first in line in the patents office, to where you're at least at that point? Or is it depends on everything?
Well, you would never know if you were first at the patent office until you're having issues. And even then you might have some issues, because even if you did the most thorough prior art search, patent search out there, for publications or for patent applications that are to be published, there's still an 18-month blackout window. So there's an 18-month blackout of prior art that comes from the patent office. So basically what happens when you file your patent application, unless you ask them not to publish it and keep it confidential, the application will publish within 18 months. And once it publishes, that becomes a piece of prior art that can be used against anyone else.
Okay.
Yeah.
Which would explain why most of the venture capital guys, investors out there, don't want to mess with patents. It takes too long.
Yeah, I mean, I go back and forth on that. I mean, I know that some VCs do. I mean, if you have a product, like a physical product,
right,
hopefully you can corner the market on some idea on that. Software and especially things that are moving super fast, that's always difficult. Like you said, when we were getting software patents for our clients, be like 5 years later, we'd be like, here you go. They're like, thank you. But we stopped doing that 3 years ago. And the reason is that the software people, they don't need to retool anything. They just hit a couple keystrokes, hit enter, and it's all different. And that's it. So, that's why software just moved too fast. And it was even too fast when you could get patents on it.
Well, I mean, if we would have had a patent on the listings engine, we would have. So that's one of our main products we have, is Simply Be Found. It goes out to 1,000+ networks. I would have killed the patent this morning because we had to change the API of how some of that part worked. And it would have been it was probably about a 13.4% change on something I made this morning. Well, that goes against it's more of a 10% change. It would have had to go refile it. It would have taken forever to refile for it.
Yeah.
And that's exactly why software does not work. It moves way too fast.
Yeah. Well, the Supreme Court solved that for you. So the idea is now you don't have to have so much concern about someone coming after you.
Right.
Right.
I mean, there's a lot of stuff that comes in there. When you are working with an inventor or someone that's looking to get that patent, do you have that discussion if it's worth going down the road of doing the patent and if it's worth just going to the market and taking the risk of someone copying you?
That I always say that's their business decision. I give them, kind of my thoughts on that. But I have to tell you, I mean, honestly, there have been times where people have come in and, hey, I want a patent, and I thought it's the coolest thing in the world, this, and it doesn't go anywhere. And there's times I've been like, all right, okay, cool, we'll do it, and they end up making a lot of money off of it. So
Right.
I can't make the business decision for them. Like,
So let's say you don't decide that your product is not worth patenting, and you go out and you start right into production with it and put it out there, and then somebody files a patent after the fact that you're out there in the market. How does that affect you? Does that mean they make you take it down? Is there a cease and desist kind of thing that happens at that point, or
they
because
can
you're
try.
Oh, okay. Well,
They can
it's just one of those
try. I
things.
mean, yeah, but they're not going to. I mean, inventions are first. If you're out there in the public before the inventor files, you win.
Okay.
So they can't stop you. Now they can make your product because you didn't patent it, but they can't stop you either. And and I always tell clients, like, look, if you don't get the patent, you can make a lot of money on a product that people like. I mean, you kind of have to get to a certain level of success before people start copying you. I mean, people aren't running in to just take your like $250,000 business away. Generally, it's something they got to see a bunch of sales on Amazon. Things all of a sudden you're starting to make millions. Then you're going to see a lot of people run in. So you can make a good living just finding a niche and then being successful in it.
Gotcha. So let's say you invented something nobody else is, the newest bread slicer or whatever, and you put it in, you put the application into the patent. What are the next steps that you would tell the business owner or that inventor to do? I mean, while you're waiting for that 18 months, you don't want to just sit there and do nothing. How do you tell them to prep for getting to hit the ground running if they do get the patent or not? It's kind of like you got to tool up, or you might win and you might not win. That kind of thing.
I tell them that the die is cast. Like, you should be trying to make money off. If you believed enough in this idea to get a patent on it, you should be trying to make money off of it no matter what. So that's neither here nor there. Go out, go forth, and prosper. That's what I tell them. As soon as it's filed, do everything you can to make money on this thing. Because, I don't know if you guys, the hardest part of making money is the invention, yes, is important, but we all know it's the business side. It's the making a market, getting it to, manufacturing, putting it out there. Those are the steps that typically trip people up. Like I say to them, while getting a patent is not easy, it's the easiest part of the process that you now have to go on.
Well, you have to build hype inside of the marketing world. So if you have a product that you want to take to market, you have to build hype around that product. If you don't build that hype, you're going to be left behind. So you have to be, you have to have everything ready to go the minute that comes through, to where you can start building that hype, to where you can, once you get the clear, if I can go through and talk about this now, you have to be able to do it. So how do you protect yourself as you're going to go work with a marketing firm or what advertising agency, whatever you're going to work with to build that hype? How do you protect yourself inside that NDA? What are you looking for?
Well, that's what I stress is use the NDAs as long as possible. And then, like you said, when you hit the market, you need to hit it. And then obviously all your NDAs go by the wayside because they only protect non-public information. And
right.
Then once, you disclose it, you're there. Now you can have some confidentiality clauses and stuff like that that will maintain your confidences. But, so what I try to tell them is keep it all under wraps, go to your marketing firm, do however you're going to attack this, try to wrap everything up until you hit the market. And then hit it like gangbusters.
That's really important, I think, and I thank you for confirming what Rob's saying about the hype, because I think a lot of people forget that the hype is so important without giving it all away at the same time. That's a fine line to walk, I would think.
Well, I think there's a lot of inventors that have a hard time of knowing the marketing side. They're really good at coming up with products. are really good at that. But when it comes to the business side, it's not something that, for the ones I've talked to that were good at coming up with the ideas, they weren't good on the business side. And that was probably one of their biggest struggles inside of there.
Yeah, as I know a gentleman. I don't know if he's still alive or not, but when he was in his 80s, he was had like 100 different patents and never took one to market. He would come up with patents and then get people to take it to market for him, and they would just pay him for the ideas. And that's another approach you can do. But I think there's more money to be made if you can actually take your product to market, I would think. Maybe I'm wrong, but that's my thought.
Well, actually, Dean, I warn clients on that. Like people who call and they're like, well, I have this idea. And I'm like, you need to have a business plan. And a business plan is, it should include more than I'm going to approach the biggest manufacturer and then hope that they make it for me, take all the risk, and then just send me money in the mail. Obviously, mail money is always your end goal. But the way I've seen it generally work, they want to see you show proof of concept. They want to see that there's a market for your idea, and you need to show them that. Now, you don't have to conquer the world, but if you show promise and then you approach them, then you're more likely to get them to pay you for your idea. And then you can sit back and, reap rewards off of their efforts. But I tell them, let's not invest. I mean, we can if you want to, but be wary. If you're investing in a patent just because you believe the only way you're going to make money off of this is going to the big company, be wary. It doesn't happen as often as most people think.
Gotcha. And that was a great point, though, proof of concept. I mean, so many people forget that, you can come up with a great idea, but it may not ever catch on. And Rob's probably seen that more than I have, where we've seen these brilliant things. You go, God, that's a great idea. And nobody likes it for whatever reason, being in the venture capital side that Rob was on.
Well, I think they're squirrels. They go multiple different directions. And you got to remember, if you're going to just take a patent and go sell it off to a big corporation, or if you want to sell that to a VC firm and want them to take it to market, for one, you're not going to have as much mailbox money without proof of concept. There's not much money there. And you have to remember also, they have to spend money to go through and check and see if you even have the patent before they buy it. Now the whole entire investigation on that ends up opening a can of worms. It's a pain in the ass too, to be able to make sure it's good. I mean, we had all kinds of people try to send stuff over and say, I have the greatest thing. I have this patent, and it didn't exist, or it had loopholes inside of it. And we have no idea how some of that even went through. So you have to remember, you're just one of thousands going to that group. Unless you have some killer idea, you have to have that proof of concept inside of there, or else it's not worth anything.
Yeah. I mean, I don't know how you feel about the show. I don't personally watch it very much, but the, Shark Tank, and I tell people it teaches you a lot in there. What's the first thing they ask you? How much money have you made? How long have you been in business? And do you have a patent? And if it's a physical object, they want to know if there's a patent involved. And it just provides a little more stability in your willingness to invest if you see proof of concept, if you see intellectual property, those kind of things. It also shows that you as a business person are, crossing your T's and dotting your I's. Like, you need to make sure you have your trademarks covered. You need to make sure you have, this is what businesses need to do.
Well, and going through, so I've been on both sides of that. I've been on the side. I've never done anything with Shark Tank direct,
right?
But we've done the whole entire pitch events to where people come in. I just was invited to go to one first of this month to be able to go through and do it. I didn't go, but to listen to pitches and how people pitch it. I'll never forget the first time I ever took a product to go get pitched, and I was the one pitching. I learned so much during that process. I mean, going back and all the stuff I learned during that, it was crazy, because you only have a certain amount of time. You only have all of that. I mean, if you look at Shark Tank, I think each of those pitches are about an hour actually long each. And they're doing 12 to 14, and then they do editing process to cut them down into those short little snippets, which more power to them. I mean, that takes some skills right there to be able to make them as what they do. But you have to have that proof of concept. Yes, they get excited when you find out they have a patent, because then they can go to, all these big box stores and they can put it in a lot easier. There's a lot of stuff for the big boys to be able to do it. But there's a whole process behind that. I still think some of the stuff on Shark Tank is there for show and to make it a show. But
hype,
just
as you
from
like to call it.
Yeah, the hype.
you have to have hype in there for some drama. But I mean, from all the ones I've really seen, either they're really good at pitching or they really suck at pitching, and they have absolutely no idea what they have.
Yeah.
And you talk about that, and I've seen where they were on Shark Tank and it failed miserably. They really believed in their idea and they went out and took it out anyway. And I've heard some success stories, not a lot, but some success stories where they took it and said, "Okay, I fixed my own problem. Thank you for the advice," and they did well with it. So they did their own proof of concept after the show, even though they didn't get an angel investor with them or whatever that is that they call themselves on that.
Actually, oh, sorry. I was going to tell you, I actually heard a horror story coming from someone who went on there. Basically, they had this product. It just got all this popularity and whatnot. I don't know if the sharks invested or not. I don't know about that. But what happened was the foreign supplier saw it.
Oh.
And so the foreign supplier contacted the direct customers and undercut the people who went on the Shark Tank. And they basically, they didn't have any intellectual property. They didn't have the proper contracts in place. They lost their business.
Oh, it's another thing where disclosure before protection.
Yeah.
So I'm kind of curious. I know that, 1 in 5 businesses fail in the first 5 years or whatever those stats are. I haven't looked at those stats in a while. What are the stats of somebody failing from having a patent or going through the process of getting a patent? Do you know those stats by any chance?
No, I don't.
Okay.
Yeah. I mean,
I wasn't sure how much success rate or anything. I wasn't sure there's any numbers behind that.
We used to when I was a patent examiner, they would always tell me, only 6% of all patents are ever brought to market. But when you work at the patent office, you realize why, because the vast majority of patents are from R&D departments of huge corporations, and they're not going to retool for every advancement they have, but they are going to cover everything they can with their R&D budget. So, half the time it's kind of the same thing, just a little different. And
right.
That's why you get so many patents.
That makes sense.
Yeah. So Austin, after you help them get the patent and you get everything done, do you stay with them to help them with the marketing and SEO side of or do you kind of say, now you need to go find somebody that's an expert in that area? Good luck, and I wish you the very best. How do you kind of do that, or do you stay with them for a while?
I'm generally like a one-trick pony. That's basically kind of what it is.
Okay, gotcha.
Yeah,
fair enough. Do what you do and do it well, right?
Right. Well, the thing is that this is fine. I believe I have a finely honed skill in this. I have some general knowledge of what they need to do and what they need to move forward. I will help them develop their business in terms of hey, if you need an employee, if you have employees, we need to work at your employee contracts. We need to look at your confidentiality agreements, those type of things. One of the biggest things that I try to, impress upon business owners is insurance. Make sure you have a great insurance agent, and if you're in an industry, that has to deal with patents, make sure you have a patent writer that is very clear about, hey, if I get sued, I have this much coverage, or, it's just one of the landmines that you can step on in business. And that's why you need the insurance in the first place.
Okay.
That makes sense. What are some of your biggest tips you'd have for somebody who has invented a product, has never taken it to market, or it has never filed for a patent? What kind of tips do you have for them taking that next step?
Well, I guess the thing is if you're serious about it, contact a patent attorney or a patent agent, and then, see if it's something that you might want to get patented. At the very least, order a prior art search, a good one. And that way, you won't be sitting there for 20 years. I should have done that. I should have done that. I should have done that. At least you have
next thing you know, you see it in the market.
Exactly. Well, I know that I beat someone to the market, but I had no investors. I was a college kid, and that was that. I actually filed a provisional patent application on my own, but I had no backing and no way to bring it to the next level. But my senior thesis in school, I built a wireless smoke detection system. And this was right at the beginning of wireless technology. Okay. And how I came up with the idea was, you know, I was a kid and my dad's had a ranch house in southern Mississippi. Saltwater aquarium almost caught fire. Dog went crazy, saved the house. But that summer, I was in the attic with him wiring the smoke detection system. And obviously, it's very hot. There's got to be an easier way. I didn't want to have to ever do that again. So when the wireless doorbells came out, So when the wireless doorbells came out, me and my buddy, we built one or two. And basically what had happened is if you sensed smoke, it would send an audible alarm and a wireless signal to the next one, which would then relay through the house. And then I went back and looked, and I believe I beat Kitty by a couple of years before they filed for their patent application on it. But, you know, it's a thesis paper at the library at the school, and, you know, it wasn't available for prior art. So
that or your buddy dated the guy, the CEO's daughter from Kitty or whatever.
Yeah, exactly. That's what it is.
I've got $1 million idea. I'll sell it to you for $20,000.
Yeah, exactly.
I mean,
and a date with your daughter. Sounds like an old farmer joke.
Yeah, no. We walked into a bar, and there we go.
Yeah, exactly.
Well, definitely. Well, Austin, if anybody is interested in talking to you and they want to go through and be able to see if their idea is going to be patentable, what does that process look like? How would they find you? And what should they know prior to contacting?
Just know that, you know, I'm here to help. I always give free consultations. I try not to talk any confidential information on that stuff. But, you know, it's easy to find me. Lucky enough, I have a very unique last name, Bonderer. No one could pronounce it until Roger Federer came out, so that was kind of cool. So just look up Bonderer and then patent, and you will find me. You'll see, you know, I'm the only guy with that name, and, you know, I have over 700 patents with my name on them. So I have a lot of Google results. All good ones, I hope. You know, like
so you're Bonderer and insured, right? So
that's right.
I was going to say, I'm sure there was all kinds of jokes when you were a kid, and still to this day.
Oh yeah. My friends tell me I went into the wrong type of law. I should have went in personal injury and the commercial rights itself. You know, called Bonderer.
Well, I mean, it's. I'm sure the engineers picked on you when you were doing your engineering.
Oh yeah, well,
I mean, I can think of all kinds of jokes that would be all for that one, all around that one. So,
oh good Lord, I'm a stupid dad joke time. It's time to get into the adhesive business. All right, here we
go. Well, thank you so much for joining us today, and it's been a pleasure.
Well, Rob and Dean, I've had a great time, man. I appreciate it, and anytime.
Awesome. Thank you so much.